you were surprised to see me here, you're not half as surprised as I am to be here. This isn't the first time this has happened to me with the Institute. Nearly 50 years ago, at the very first conference that the Institute arranged on international development, on the Wednesday, Ken Simmons, who was then the director, said, "The man from East Germany isn't coming." This is 1966. "The man from East Germany isn't coming. You will have to do a paper on Saturday." I said, "I don't know anything about international development." He said, "You will soon find out." And what I did find out was a very orthodox account of the sources of international law to which Gerald Fitzmaurice's name was attached. I need say no more. And so I satisfied myself by demonstrating there was no international law on development, and it all fell rather flat. There was certainly no East German account of what that law might have been. Some things have changed. When I did that talk, it was at Ditchley Park all those years ago, I was given a glass of water and I said I had to write my script. Today I've got a script. And I've got a gin and tonic, which shows that some things change. And one thing that I think all academic lawyers of my age and close to it would say is that international law teaching became a lot more interesting about halfway through my career. And there's almost a moment in time when that happened, and it was when Arthur became legal advisor and came round all the law schools soliciting support, really, for whatever initiatives the Foreign Office could take within, of course, as they still say, our restricted budget and the considerations of confidentiality, which was always been the excuse before why there could be no collaboration between the legal advisor's office and academic lawyers. But Arthur changed all that. And one of the big ways he changed it was by the initiative of the Foreign Office Academic Seminar. And particularly at the beginning, these were an utter revelation to those who were academic lawyers. We found that we were actually speaking the same language and we were interested in the same things. The Foreign Office usually got it wrong, but there was something to be done together. And it did, for those people like me of a positivist inclination, it made a huge difference to know something about British practice other than the tiny bits filtered that we'd heard about before. And that I think is all down to Arthur and his sort of public spirit about it. The awkwardness about some of the questions that were asked at these seminars for the legal advisors was, of course, that they didn't always want to answer them. And they didn't have the same techniques for dealing with them. Arthur would just say, "I'm not going to answer that." When Frank was a legal advisor, he was the chairman at every single session. And he sat there, and if an untoward question was asked, he kept talking until the end of the time for questions, when there was no possibility of furthers and betters to be sought or delivered. Now, I am going to do my best with Vaughan's, which is be my fault, not Vaughan's, if it doesn't seem to measure up to you. It is, there are elements in it which are autobiographical, and so from now on, when I say it's Vaughan that's speaking and not me. But I do want to say that I support entirely the very warm things that he has to say about Arthur. I didn't know him anything like as well as Vaughan, but I knew enough to know that here was somebody of substance and generosity. So now it's Vaughan. The title that he gives this paper is Making International Law Work. Just in brackets, I would say, and Vaughan would say, making work for international lawyers. It's more like the thing that he would be interested in, but there we are. So now this is Vaughan. It says, I am grateful for this opportunity to pay homage to Sir Arthur Watson to the British Institute. In their different ways, they epitomise what I think of as the British tradition in international law. A focus on the practical, on the law as it is, rather than the law as it ideally would be, and a concern with details of specific cases, rather than Procrustean attempts to force every situation within the confines of some legal paradigm. I first met Arthur when he was still Mr. Watts and he visited Manchester as part of the Foreign Office's efforts, greatly valued and appreciated by academics, to build up links with the lawyers in British universities, through such visits and through the wonderful annual seminars mounted by him and his colleagues. I came to know him better after he left the Foreign Office. We both appeared in the ICJ in the Palestinian wall case, and his pleading in that case was a masterclass. Clear, precise, unaffected and comprehensive. Without ever appearing patronising, he made it seem that he was not so much arguing a case before the court as taking the court to the evidence, where it could see for itself the obvious and ineluctable correctness of the position of his client. This capacity for cutting through the complexity of the principles that really mattered was a characteristic that he shared with his co-author of Oppenheim, Sir Robert Jennings. The very opposite, and this is in inverted commas, of clever lawyers, whose arguments can leave you feeling for your wallet and feeling that they've just seen the Temple's equivalent of a three-card trick. They both had the ability to set out arguments that had the solid comfort of complete clarity, simplicity, and a robust concordance with common sense. One can only hope that legal education continues to strive to inculcate such admirable qualities. I wouldn't be so sure. Later, Arthur and I worked together, as he has with so many in this room, advising governments and turning over the implications of various courses of action that they might take. I learned a great deal from him, not least when to stay quiet and let others slide down the ropes of their own argument. I also learned that knowing the law or establishing the law in a particular situation is only the beginning of a lawyer's work. The real effort and the real skill comes in translating abstract legal principles into practical realities. Make international law work. And that is my theme. We share a common concern with making international law work, that is, not being content with inscribing rules in the canon of international law, but in trying to ensure that the rules are made effective. Where there are deficiencies, the temptation is to augment international law. For example, the International Criminal Court was conceived as part of the solution to the perceived problem of the impunity of those guilty, I might say accused, particularly serious war crimes and crimes against humanity. Augmentation may take the form of adding new institutions, such as the ICC, or new procedures, such as the increasing number of procedures under which individuals have access to international bodies in relation to complaints that they have been treated in a manner contrary to international law. The innovation seeks to fill what are perceived as gaps in the system, in order to make it more effective. Innovation rarely takes the course of abolishing institutions or procedures that have outlived their usefulness. And the idea that a gap might be better left unfilled is also less common than it might be. But for better or for worse, the past 70 years have seen the dramatic growth of new means for implementing international law on the international plane. Innovation may take the form of new rules. The effort to secure agreement on mandatory rules on greenhouse gases is an example, driven by the belief that mandatory rules will be more effective than targets and voluntary codes. Lawmaking may take the form of new perspectives. The continuing concern with the relationship between investment protection law and human rights is an instance. Parenthetically, I note the idea of a debate over the relationship between two bodies of international law is a depressing phenomenon. Such a debate would be remarkable in municipal law, where the natural focus would be on what the rules are and how they should be interpreted. The different position in international law is explicable by the facts that A, there is no homogeneous body of law, but rather a collection of blocks into which a given state may choose to opt, rather like the EU is becoming, and B, there is thought to be a vacuum in the place where municipal law would affect the reconciliation of rules which seem to point in different directions for the resolution of a dispute, in a way that public policy carves out exceptions to the respect for corporate personality in the lifting the veil cases, and perhaps C, an excessive degree of specialisation and compartmentalisation in the academic discipline of international law. And I would agree with that last point very substantially. In all of these areas, the invisible College of Legal Scholars performs a great service, considering the need for development and evaluating the steps currently being taken in order to take a broader view of international law than practitioners can usually take. The British Institute is a major facilitator of such activity through the ICLQ and initiatives such as the International, what's it called, TF, something forum, treaty forum. The latter, an innovation...
Investment treaty forum.
Right. With which Arthur was closely involved, and which now regularly attracts to its annual conferences eminent practitioners from all around the world. But my focus in this short talk is on none of these approaches. It's on two more modest enterprises. The first is knowing what international law is. The first is the enhancement of the understanding of what international law is. Law is strong where it is coherent and well understood, where whatever angle the question is approached from, one moves towards a similar answer. That is an area where Arthur Watson and the British Institute have not only served lawyers well, they have served international law well. Oppenheim and such volumes as the British Institute studies on damages and on evidence in international litigation are examples. They stand at different ends of the spectrum. Oppenheim's broad propositions simplify the law and express its skeleton, the principles sometimes obscured under the weight of detailed regulations, qualifications and accommodations. The British Institute volumes plunge into the mess of detailed practice, trying to identify hard principles, or at least the main trends in contemporary practice. Both tasks are indispensable. The compass and the map without which practising lawyers would be sadly lost. Those of my generation have seen the importance of this work firsthand in the way that European Union law emerged from footnotes in international law texts into a fully fledged subject in its own right. Fledgling, with some of the attributes of the fledgling cuckoo, was nurtured by writers such as Wyatt and Dashwood and Lipstein, who one can fairly say made the subject in this country. The Institute continues work of this kind with its training programmes, such as those run for Iraqi and African government lawyers, of which you can find details in the Institute's annual reports. The second enterprise is the task of translating international law into municipal law, of securing its implementation and thereby securing its effectiveness. This is my main focus. Stepping back for a moment, I should say that I do not think that the notion of effectiveness of international law is self-explanatory. It does not consist in the obsessive and literal conformity of the letter of the law. One characteristic of a civilised society is surely that its citizens have the confidence to break the law when the literal application of that rule is both senseless and harmful. Have in mind the bus driver who refused to allow a motorist whose car was on fire to use the fire extinguisher on the bus because he needed permission from head office. The effectiveness of the law does not even consist in 100% success in imposing the law as reasonably interpreted. In allocating resources to policing and other social purposes such as health, education and the infrastructure of modern life, we implicitly accept that a certain level of law-breaking will go unpunished and undetected. If we knew that a 300% increase in the number of police might lead to a 10% fall in reported crime, many, perhaps most, would say it would not be worth it and the money would be better spent elsewhere. So what does effectiveness consist of? I'm tempted to say that it is a level of conformity with the law that makes the decades that each of us spends on this planet not only tolerable, but also in a broad sense just. Everyone should be able to live in the world, not spend a lifetime fighting against it and surviving in spite of it. And in addition, the general acceptance that even if the law is not always enforced or complied with, the law is always available as a framework within which instances of law-breaking may be addressed. Speeding is not always punished, but we all accept that if it were thought right to prosecute on a particular occasion, the criminal liability would be there. Even if my heart is in the right place, that response is facile. Lawyers stand between universal eternal values on one hand and mortal, vulnerable people and the ceaseless constraint of practicality and the demands of the moment on the other. The desirable level of effectiveness in terms of compliance is something to look at case by case. The tension between terrorism laws and civil liberties is a glaring example. There is no single correct solution, let alone one that is correct in all countries and for all time. The choice between equally plausible solutions is what politics is all about. So what should lawyers worry about if the aim is not a perfectly law-abiding society? Finding mechanisms that are most likely to lead to the maximum level of conformity to the aims behind a particular legal rule, spelling out their advantages and disadvantages and their likely side effects, good and bad, and then leaving it to politicians to choose among those mechanisms. I didn't quite get the balance right there. Those mechanisms are by no means all about enforcement. Often they're about organising life so that compliance with the law is a natural thing to do, rather than the option chosen under the threat of punishment for law breaking. So the question in the case of international law is, how do we get into the marrow of the skeleton of the body politic? How does a state make itself an essentially law-abiding people, rather than a nation of spivs and chances, playing the law up to its literal limits, then wriggling grub-like through the nearest convenient wormhole? I think we look at that metaphor again, Vaughan. The metaphor is tailoring. This is another metaphor. The metaphor is tailoring, adapting international law to particular conditions of the domestic legal system. Not a one-size-fits-all approach, but an understanding that in every state, international law needs to be moulded, modulated, to fit in with the national legal system and its institutions. For the inescapable fact is that most agents who have cause to apply international law are national, not international officials and lawyers. A good example is the manner in which states have addressed the problem of piracy off the Horn of Africa. With the rise of piracy in the area, some argued that new treaties or a new international court for piracy was needed. But the need was not for new rules, although the Djibouti Code of Conduct of 2009 was a valuable restatement of how states would exercise their existing rights and fulfil existing duties. Nor was there a need for new courts. It was for ships and for arrest procedures that would support successful prosecutions in domestic courts. Arrangements were made for the trial of alleged pirates in states near the place of arrest, far more satisfactory than requiring the arresting vessel to sail home with prisoners camped out on the restricted accommodation on board ship for trial in the flag state. Comprehensive and detailed protocols were drawn to specify how boardings, arrests and seizures should take place and be recorded, whether by video camera or contemporaneous written note, for example, so the evidence satisfies the evidential and procedural requirements of the laws of the state where any eventual trial will take place. An often cited example is a requirement under Kenyan law that a criminal charge concerning the unlawful use of a weapon requires the production of the weapon in evidence, a requirement that clashed with the common practice in which arresting naval ships threw the pirates' weapons overboard in order to put them beyond use. These are the kind of detailed questions of implementation that are crucial to the future of international law. It's not enough to devise laws or even to enact them. One must ask how they will sit, how they will work with the grain of social fabric and the existing laws and procedures in the states in which they are to be implemented. To take an example from another field, international environmental law, the ban on CFCs worked because there was a ready alternative in the market. The proposed ban on greenhouse gases is failing because it's cutting across not only the entrenched interests, but more importantly across the aspirations of the industrialising world. CFCs and greenhouse gases are different problems that require different approaches. The adoption of texts banning or restricting them is of very little use unless it pays regard to such differences. Working with the grain is, I think, very obviously the key to the success of international law and to make it more effective. And the challenge for international lawyers is to identify the best ways of doing so. There are good examples of innovative thinking. Last year, the UK was among states wishing to stop a Russian ship, then I believe sailing under the flag of Curacao, the motor vessel Aled, delivering helicopters to Syria. The captain knew enough international law to chart a course avoiding the territorial seas of the UK, Denmark and the Netherlands. But the voyage was thwarted by the cancellation of its insurance cover. Enlisting market mechanisms as an alternative to the possibility said to have been contemplated by the British government of stopping it in British waters was an elegant and effective way of securing compliance with the law. Well, I leave that to you. To take another example, building in compliance with international law as a criterion for the grant of insurance cover by the ECGD or the grant of foreign aid is a powerful weapon. And the use of domestic laws to enforce international obligations, as was said, during the Caterpillar campaign and more generally under the Alien Tort Statute in the United States and also in the various disinvestment campaigns, can also advance the application of international law. Equally, if not more important, is the internalisation of the rules of international law. Organising bureaucracies, corporate and governmental, so that the check for consistency with international law becomes part of the routine as much as it does with the check for compliance with national law. And I must emphasise that this is not a matter of box ticking. Law should be applied deliberately and thoughtfully, not mindlessly and regardless of the consequences. Law is always a means to an end, and not an end in itself. And it is part of the nature of law that its rules are rarely drafted with such specificity that a given set of facts positively requires the adoption of a unique legal solution. It is the nature of social rules that they lie in an institutional social framework, and the presumption that the exercise of a modicum of discretion by those who administer, well, sometimes that residual discretion flies out of the window, dragging common sense with it. So the question is, what mechanisms are there for promoting compliance with the rules of international law, and which among them is the best? One way of getting an answer is by the comparative study of implementation mechanisms. This is exactly the kind of exercise at which the British Institute excels. The collection and compilation of information on domestic responses to international legal obligations is an excellent way of starting the consideration of the range of different enforcement mechanisms that may be employed, and often yields an illuminating insight into the advantages and pitfalls associated with different enforcement mechanisms. One example is the implementation of piracy laws in East Africa. I'm told that the obligation imposed on the navies of the Council of Europe states when dealing with pirates to comply with the European Convention of Human Rights has had a much wider effect. Prisoners and their lawyers see persons accused of piracy benefiting from prison conditions and court procedures that are convention compliant and financed in part by the arresting states, and ask why land-based robbers and brigands do not have the same advantages. The result of the cooperative enforcement system was, anecdotal evidence suggests, to lead to improvements in the criminal justice system that extends far beyond the trial of pirates. Not all solutions fit every legal system. Rules on evidence in national criminal laws may impose constraints on the prosecution of international crimes such as piracy, for example. But the best solution to such difficulties may not be a revision of piracy laws or a new international piracy court, but rather the enhancement of international judicial cooperation, which may bring with it much wider benefits, and those benefits and those side effects should also be taken into account when deciding how best to implement international law rules. I'll close with two general points. First, in broad terms, it seems to me that dualism, the transformation and adoption of international law to the particular circumstances of each national legal system, is the only rational approach, and indeed the only tenable theoretical position. I agree. The idea that rules of international law can be directly applied as such in international domestic legal orders without any mediation to integrate them into the domestic legal system seems to me to be unsustainable. It follows that the uniformity of implementation of international obligations among states is unlikely to be achievable or even a desirable goal. The need is for each state to comply with international obligation in the way that suits it best. Second, the inquiry into what is the best approach to implementation is essentially an inquiry into empirical and not theoretical matters. If, to take an example from the laws of war, the aim is to prevent attacks upon schools and hospitals, one ought to ask whether the result of outlawing attacks upon them increases or decreases the installation of gun and missile emplacements around schools and hospitals. Reports from the Middle East, which may be misleading or untrue for all I know, suggest that the supposed immunity of such sites from attack makes them very attractive as military sites. And of course, in an empirical inquiry, one would have to take into account the capabilities and effects of the various weapons. I emphasise that my point is not that schools and hospitals should be liable to attack. It's a question how best their immunity from attack, or more precisely the protection of the personnel, facilities and services there, rather than the complete immunity of the hospital site as such, is secured. One might ask similar questions in many other contexts. Are the current arrangements for the right of individual petition to the European Court of Human Rights the best way of securing compliance with the Convention? Well, they are in this country. It is better for a state to exercise its maritime... Is it better for a state to exercise its maritime jurisdiction by enacting specific laws for maritime zones, or is it better to say that all of its law applies in territorial sea? These are not simple questions. They're questions that require careful analysis and consideration. The need is not for a single grand theory on the relationship between international law and domestic law, but a careful consideration of the contours of each particular domestic legal order in which the implementation of the rules of international law is required. This is the kind of task the Institute is ideally placed to undertake. The range of experience and skills upon which it can and does draw, from the youngest intern to the most distinguished judges, government officers and practitioners, gives it a unique advantage in such work. And it is work of that kind that makes the Watts Fellowship such a fitting memorial to a fine lawyer and a good friend of the Institute. And the many in this room have spent his career trying to make, one of the many in this room spent his career trying to make international law work. Now, it may not be Vaughan that was here, but I think you can see the spirit of Vaughan in that lecture in quite substantial detail. Thank you very much.